In this video, we will continue our look at contract modifications under Article 2 by considering the effect of the UCC's Statute of Frauds on modifications. Recall that the UCC Statute of Frauds, Section 201 of Article 2, imposes a writing requirement for any sales contract for the price of $500 or more. So even if a contract the parties originally agreed to is not subject to the Statute of Frauds, that is because the contract in its original form contemplates a sale of goods for less than $500, the contract may still be brought within the scope of the Statute of Frauds through a subsequent modification. This rule is spelled out in subsection 3 of 209 in Article 2, which reads that the requirements of the Statute of Frauds section of this article, Section 201, must be satisfied if the contract as modified is within its provisions. This statutory provision means that a contract that was not originally subject to the Statute of Frauds writing requirement may later become subject to the writing requirement if it is modified to contemplate the sale of goods for $500 or more. Note, however, the Statute of Frauds applies only if the contract as modified exceeds the $500 threshold. So, if the original contract between the parties is below the $500 threshold, but then the parties orally agreed to modify the contract to increase the amount of goods subject to the contract, but the modified agreement is still below the $500 threshold, then the Statute of Frauds is still inapplicable. Stated differently, the Statute of Fraud poses no barrier to the enforceability of the modified contract. But imagine if the parties orally agreed to modify the contract to an amount that exceeds $500. Then the Statute of Frauds applies to their modification. Stated differently, though the parties may have both assented to these modified terms, the modification is legally unenforceable. One party may later disavow the modification, unless the modified agreement satisfies the writing requirement of the statute or an exception to the writing requirement is available. Here it's useful to recall what the Statute of Frauds requires in terms of writing. Press pause for a moment and think about it. Remember, all that is required under Section 201 is that we have some kind of record or writing indicating that a modification was agreed to, signed by the party against whom enforcement is sought, and stating a quantity of goods involved. One final point to emphasize with respect to 209 subsection 3 is that it also works in the opposite direction. That is, even if the party's original contract is subject to the Statute of Frauds and there is a sufficient writing that meets the statute's requirements, if one party alleges that the parties later orally agreed to reduce the amount involved to below the $500 thresholds, the Statute of Frauds would not apply to the alleged modification, because the alleged contract as modified would be below the $500 threshold. Note, however, that even in this scenario, where the Statute of Frauds is inapplicable and therefore does not pose a barrier to the enforceability of the modification, the party alleging that this modification was actually agreed to still bears the burden of proof to adduce evidence showing that this modification was in fact actually agreed to by the parties. But the Statute of Frauds would no longer present an issue with respect to enforceability. So in this video, we looked at how the Statute of Frauds may make a subsequent contract modification unenforceable. Simply put, if the contract as modified involves the sale of goods for $500 or more, then the contract as modified is unenforceable unless it meets the Statute of Frauds writing requirement or an exception to the requirement is available. In the next video, we will conclude our look at contract modifications by looking at the effect of no oral modification clauses.